Yes, Your Lordship.
Notice was issued. They have taken steps.
Notice was issued.
Notice issued, private notice. Have you taken steps?
Yes, Your Lordship.
Where is the proof?
Everything was received.
18 not received. It's a court notice.
Yes, yes, official.
This is court notice. What about your private notice? Sir, you have to send. You have to send
Yes,
a
Your Lordship.
notice.
Yes, Your Lordship. So I have given to the registry by Talhavana and
The registry notice is different.
This here is that we have to take steps, make the petition ready, give it to the registry, pay the postage registry.
That's only that. There's no private notice at all.
That even until and leave court says that it is to be done by us. You know, that is
Who appeared in the writ petition?
Its counsel is appearing that they are not accepting the notice, Your Lordship.
They have not.
They have not accepted the notice. I requested, Your Lordship.
You attempted to serve notice on him.
I request, but they didn't.
They didn't take it.
Yes.
It's a post after service. Notice awaited. Service awaited, sorry. Service awaited. What's the matter on maybe around 20 to 18th. We'll have it on Monday 7th or 8th. 8th is Monday. 8th.
Even petitioner can verify the status of service. Petitioner can verify the status of service. This online tracking is available. They can verify the status of service at valid affidavit.
So why don't you track? Because you are filing the proof, is it not? So you are giving the postal receipt, everything to the registry.
Okay.
So they are dispatching it. If you have the number, tracking number, you can track and file a proof of service.
Okay, Your Lordship.
Yes. All right, service.
Item number
What's on
2.
8?
Yes.
In Chennai, as long as the notice is
Yeah, what they can make everything ready. And the registry puts select the amount and we will register the report.
Please, Lordship. Lordship, I appear for the sole respondent for the first time today.
You are appealing for the
The sole respondent, but
respondent. Yes.
the writ petitioner in the...
ESA Corporation.
No, I am for the respondent here, my lord.
Yes, yes.
Yes,
ESA Corporation is the appellant.
Lordship, yes.
But there is no lawyer for ESA Corporation.
Delay was of 94 days, my lord. For the delay, I have no objection for it to be condoned.
The respondent has no objection for the delay being condoned. Yes, the delay is condoned. Today also there is no representation for the ESA Corporation. Then we must ask the director to appear, ESA Corporation, director to appear.
They have filed it through the deputy director in charge Northeast region.
Yes, yes. Deputy director, everybody is there. Then on merit, so what is your case?
On merit, my lord, my principal contention before the writ court was that this notice which was issued to me under section 45 of the SI Act was without jurisdiction, my lord. It was a question of jurisdiction, not on the quantum.
If you have any grievance on the notice, you have got a right of appeal under 45 AA.
Lordship, yes. If I may just, if Lordship will take it up today, then I can just show, my lord, what was our principal contention.
Tatappa, you read section 75G. Last time we pointed out to the to you only, is it not?
To the appellant, my lord. I did not.
You see 75G?
Lordship, I have here, my lord, if I just read out one paragraph from the impugned judgment, that is what the learned court has, writ court has, my lord, seen. If I may just read, my lord. two paragraphs of the judgment at
Page number?
70 of the appeal paper book.
Para 17.
No, page number 70, paragraph number 16.
Oh, yes.
It starts with, without going into the merits of the case of the parties as noted herein above, what is apparent is that the petitioner at the outset has outrightly denied being the principal of employer or proprietor of MS so-and-so, in the absence of any evidence as to the existence of such an establishment at Moblai, Shillong, which was the place where the alleged inspection and survey by the said SSO has taken place. The fact that no records of any employees, not to say of 10 employees or more being employed by the said establishment is available, would only lead this court to believe that the basic dispute would be an issue of facts. It is well settled that this court, more often than not, would not, in judicial review, go into disputed question of facts between the parties, though, as observed in very exceptional and rare cases, facts could be gone into. However, in this case, the initial resistance of the petitioner is that he is not the principal employer of MS so-and-so. This being the case, the provision of section 75 of the ESI Act would not be applicable, since the provision itself speaks of adjudication of disputes by the ESI court as regard dispute which arises inter alia involving the principal employer and the corporation, or between a principal employer and an immediate employer. Therefore, if the status of a principal employer cannot be attached to the petitioner herein,
I think you get the ESA Act. I think the power of the civil court is ousted. The power of the civil court has no powers.
which is why we came before the writ court, my lord. However,
Who came?
we had,
You came.
yes, lordship.
That is not
My writ petition was dismissed on one hand. At the same time, I was directed to approach the civil court to decide as to whether I am the principal employer or not.
all those things can be adjudicated and the
And another submission, my lord, in Shillong, I believe there is no ESI court.
where?
In Shillong, there is no ESI court, my lord. Usually what happens is a particular judicial officer, a magistrate, is assigned the duty. And it appears, my lord, that the last presiding officer, that duty is assigned by name, my lord, not by the office. So even at the time of filing of the writ petition, there was no judicial officer designated as an ESI court. And I believe that is also the position now, my lord.
Civil court has no jurisdiction to try the matter.
75(3), my lord, that would.
What is it, 75? They're having 75.
3.
C. No, you see 75G.
75G, lordship.
75(3) is with regard to civil court, no jurisdiction to do any question.
Lordship.
Correct.
Lordship.
But 75G,
Lordship.
75G clearly says
Any other matter which is in
Or any other matter which is in dispute with the principal of the corporation between employer so and so. But only ESI court alone is empowered to do it. 75(3) will not be because
my lord, our only contention was that,
but how do you say in Shillong there is no ESI court?
as far as my instruction goes, my lord, that the person who was designated earlier has since been transferred, and it is my instruction that as on date, no one has been assigned that duty yet till now, my lord.
As an ESI court, sometimes the labor court may be designated as an ESI court.
Here, my lord, what happened was, when we filed the writ petition, my lord, one Mr. J.A. Marak, who was otherwise a judicial magistrate of first class, was assigned the duty by name to function as a ESI court, not as a separate establishment per se, my lord. Thereafter, he was transferred.
So the court is there, but judicial officer is there,
Yes.
but government has not notified.
Yes, that is my instruction. I may not be, my lord, very
Who is
correct.
appealing to the state government?
State is not a party, Your Lordship, in this case, I believe.
Thursday, you may not be a party here. The problem is the benefit of ESI has got to be extended to the employees or not to be decided.
Then Lordship.
See, the problem is same thing. There was a problem in 1985-86 when the central government industrial tribunal was there. The person who was holding the Tamil Nadu Tamil Nadu Industrial Tribunal was nominated as a central industrial tribunal by name. Then, suppose the person transfers, unless a separate notification comes, he cannot take up the matter. Then ultimately they realized that there was a problem. Then they started that Tamil Nadu Industrial Tribunal can take up all the cases pertaining to central government industrial tribunal matters. After 2000, central government tribunal has been constituted. Still, the central government, the ESI matters pertaining to the central government cases are tried by the principal labor court. It is nominated by the, notified by the state government.
Let me have instruction, Your Lordship, as to whether the government has notified or not.
So as a year, why is nobody? It is very unfortunate that there is no council representing the ESI corporation. This was recorded on 6/3/2024 and the matter is posted today under the caption dismissal. Today also there is no representation. The council appearing for the respondent writ petitioner submitted that he has no objection for the delay being condoned. After condoning the delay, then this court posed a question as to how the writ petitioner is maintainable, bypassing the remedy under section 75G. Come on, you would submit that there is no ESI court functioning and that the civil court has no jurisdiction to take up the matter and he has no other option except to oppose this court. Full stop. This court ordered so-and-so to take notice on behalf of the state government and so-and-so represented by state is added or impleaded suo moto as respondent in this writ appeal. The government is expected to inform this court in the next date of hearing as to why there is no ESI court. In this state. The petitioner replied and reiterated. The petitioner reiterated that a judicial magistrate of so-and-so was, by name was designated as ESI court and that he has been transferred and that there is no ESI court at all. First up, the government should think of designating a particular court instead of naming a person to be the presiding officer, which may create a lot of hurdles for disposal of ESA cases, as the benefit will have to reach the employee and the family members if they are otherwise eligible. There was a matter on we posted on 21, April 22nd.
Let it be in the first week of April, Your Lordship.
First week of April.
Lordship, yes. Any day.
Yes. Post on 8th April. Post on 8th April. The Apex Court has categorically observed that the High Court must be slow in asking the officers to appear before the court, and that they must be given an opportunity of appearing through virtually initially, and thereafter, depending upon the progress, the court can take a decision. In this case, this court has posted the matter for dismissal, and that in order to have the assistance of the deputy director, who is the appellant, we expect him to appear before this court in person. We'll stop.
Lordship. So sorry, Lordship.
Yes, what happened?
Last occasion I could not come because my brother-in-law met with a severe accident. He was admitted in Longpo Bethany Hospital. So that's why, Lordship, I could not come. And today I got stuck in traffic jam. So sorry, Lordship. My apology.
We'll change it accordingly. There's also there was no representation earlier, and today the council appeared and submitted that a brother-in-law met with an accident, which resulted in a non-appearance. So we changed that and they asked the deputy director to appear on virtually. Ask the deputy director to appear virtually.
Yes, Lordship.
See, you must ensure that the state government notifies a particular court as a ESA court.
Yes, Lordship. Now,
You can't keep quiet whenever there is a problem at that time, you can take steps or remedial measures.
Lordship.
75(3) will not come to your head. Says that civil court has no jurisdiction means you can't come to the High Court.
So, my lord, if it is clarified, if there is a particular court functioning as the ESI court, then we'll take
That apart, you must understand one thing. This is a decision under 45A. You have got a right of appeal under 45AA. I think period is 60 days. You should have gone before the authority. You can bypass that 45A and go before the ESA court, because the ESA court prescribes 3 years limitation, whereas 45AA prescribes only 60 days time, and that there is a condition precedent for depositing 25% of the amount, the actuals, the form C8 and the available. You would have done that.
You have directly come to on the issue of jurisdiction.
No. It's a disputed question of fact. Even the learned judge in the last paragraph has observed that it's a disputed question of fact. How can this court adjudicate?
Which is why, my lord, the writ petition was dismissed and we were directed to go to the civil court. And we have thereafter filed it also.
So civil court, that observation is not correct. Civil court, ESA court and ESA court alone can do it.
If the ESI court is functioning as on the next day, we'll take instruction on that regard. If the ESI court is there now, maybe someone has been designated or not.
We have made him a party let them also appear and see, they should get the relief immediately. Yes.
You give this, you have extra copy. If you don't extra copy any? Huh?
The ESI book or workman's compensation book published by Universal, I think I found some mistakes when I was in Chennai. I don't remember. I'll try to get the, because I have written it the docket, the book cover itself, saying that wrong, I think mistakes are there in the book. Don't refer to this book for this enactment. I don't know which book. In the universal publication, there was a mistake. Yes.
From supplementary list, item number 1.
Your Lordship, in this case, we didn't have any objection to transfer the case.
Sir?
This, in this case, I got the instruction, Your Lordship, that petitioner is not having any objection to transfer the case.
Petitioner is not?
Petitioner is not having any objection to transfer the case in Shillong. Because presiding officer, she was one of the counsel in the instance case.
No, I'm not able to.
In this case,
Here,
Your-
the presiding officer, this case pertains to Ribhoi district land acquisition case. So, Lordship, here what happened, presiding officer in Ribhoi district, she was the conducting counsel for the claimant when she was a practicing.
Ah, correct. Yes.
So, Lordship, what happened now, she has, on her last order dated 22 February, she has passed an order that she cannot take up the matter, and thus the matter is transferred to High Court for hearing on transferred case. So, Lordship, here, since she cannot take up the matter, so we propose that matter may be transferred to East Khasi Hills district because she is from Ribhoi district. To which my learned friend is saying that he do not have any objections
No objection.
that if the matter is transferred
So
to
when the matter is taken up for hearing, it is represented that the presiding officer so and so has already appeared for one of the parties. The parties have no objection that the matter may be tried by so and so. In view of the same, the entire papers are directed to be transferred to the so and so court, and the court is expected to try the matter and bring the issue to the logical end within a period of 6 months from the date of register of this order. As the reference, this is under 30. The reference is of the year 2015.
Item number 2. My lord, I'm praying if this matter can be taken up at the end of the board, my lord. My lord. Yeah, supplementary. Jeez.
What is the matter about?
This is regarding, my lord, non-payment of salary, my lord, of a school teacher. Non-payment of salary of a school teacher.
Non-payment of salary.
My-
Pass over.
Obliged.
But she is a junior.
Ballots.
She can do it.
Ballots. Let her argue the matter.
Ah, that's what.
I'll be there to assist her. Ballots.
Yes. to read it, read the papers
My lord.
and argue. If you have any difficulties, we'll ask your senior.
Okay. Item number 3.
3 and 4 are connected with item number 2, Lordship.
2 and 3 are connected with item.
Item number 2.
Yes. You're ready. What is the matter about?
Lordship, let the senior counsel argue first that item number 2, Lordship. This is are connected. Same only, Lordship. Non-payment of salary.
Lordship, I'm in number 3 and 4. 3 and 4. 3 and 4. Number 2 is listed by
3 and 2 is
3 and 4. I'm there, Your Lordship. 3 and 4, yes. But so far, item number 2, oh, he has come. This year, he has come, Your Lordship.
So 2, 3 and 4 are connected.
Yes, my lord. End of the bottle.
Wait. 5.
From the
Take
daily,
them.
Well,
from the daily list, item number 1.
What is the issue, sir?
My lord, this is with regards to the non-grant of assured career promotion scheme, my lord. ACP and MSCP, my lord. I prepared a
So assured career progression.
my lord.
Give the copy. You got it?
well,
Ready? Or want some other day?
but he can start, my lord.
He will start. He will also pass orders. Only thing is you should not take urgent in the middle. That's why we are asking. First question is not only here. Ever since I assumed office, I'll ask the other side. Otherwise, one side will argue, and the other side will take an adjournment after the argument on the first.
My lord, I can argue.
Yes.
There's only a point of law, my lord, involved.
Yes. How many cases are there? Only one case. Yes.
My lord. One of the petitioner was
How
enrolled
many
in
cases are there? One more. This is case number?
Number 2 of the minutes.
First item, the.
First item.
Oh, then it's. Yes.
my lord. The petitioner was enrolled in Assam Rifle, my lord, on 29th July 1994 as a rifleman ORL. ORL means, my lord, operator radio line, ORL. It's a signal man.
Yes.
In the year 2012, my lord, he was promoted to the rank of Havaldar. Havaldar ORL. On 10/10/1997, my lord, Government of India has restructured the rank and the pay scale, my lord, by redesignating the posts, wherein the respondent authorities were not implementing the said rank structure and pay scale, my lord. The similarly situated person has to approach this honorable court and got a direction that for implementation of the said notification dated 10/10/1997. Thereafter, my lord, the said notification was implemented by the respondent authorities, whereby, wherein I had to get a ACP benefit of the ACP assured career promotion after completion of 10 years of service. 10 years of service. But the respondent authorities has treated that implementation of 10/10/97 notification
Prospectively.
as a promotion, man. That upgradation they are treating as a promotion.
Where is that?
My lord, para 2 of their affidavit, my lord.
Yes.
Page 2, page 3, my lord.
Page 3.
Page 3, my lord. A.
Page 3 of the counter affidavit dated 12/5/2017.
My lord.
Yes.
They have A, my lord.
The petition was enrolled in Assam Rifles, the scale of so and so, promoted to the rank of Havildar. Yes.
On 1st March 2012, my lord. Which is in, my lord, can come to.
So according to you, after 10 years of service from 1/10/13/2012,
Yes.
you are entitled to the modified career progression scheme.
My lord.
That's your case.
My lord.
And where is the proof to that effect? Where is the rule to that effect?
My lord, before that, my lord, just para C, it's the contrary stand they have taken, my lord.
Page 3.
Page 3, para C, 2C.
The deponent denies the statement and averments made in the writ petition except those that are specifically admitted hereunder. What is there?
My lord, on such and such, the petitioner was granted the.
Sir, he did not go into, sir. You tell me that you are entitled to for this modified career progression scheme, MACPS. For that, you show the rule. Automatically, you are entitled to.
The rule is at annexure, my lord, of the writ petition, my lord, annexure 2,
Page number.
page number 27, my lord.
Annexure 2. Yes. These are all the expenditures and pay scales. Where is the evidence to show that you are entitled to after 10 years? That's the only point, sir.
My lord,
According to you, that's the only point. We must hear the other side.
ACP वाला काम है. My lord,
So you cannot read it here. You should have come prepared. When you give the list of dates, similarly, Junior must give you the points also where we have to look into it. You will be turning, I will be turning, your friend will be turning. It will not be a progression scheme, it will be an aggression scheme ultimately. And if you do like this,
my lord, the operative, that's page 28, if I take your knowledge to page 28.
is the 10th February 2000.
28 of the writ petition, my lord.
Yes, yes, writ petition,
Yes, ma'am.
not the counter.
No, ma'am.
Yes, sir.
My lord. It is 12 years and 24 years, my lord.
Where, sir?
My lord, 3.1 itself.
6.1.
3.1.
28. Promotion can continue to release on the proposed to adopt the ABC begin motivate so and so. Two financial upgradation month of so and so. On completion into 12 and 24 years, subject to condition Annex 1. Release respectively. Where is Annex 1?
Annex 1 is at
Page 32.
my lord.
ACP scheme administration merely placement in the highest form. So, ACP shall be allowed 12 years of regular service, 12 years of regular service. How many years of service you have rendered?
As of now, my lord,
At that time, not now.
at that time, my lord, I have completed 10 years of service now.
But you require 12 years of service.
My lord, that's 12 years of service is the modified assured career promotion, my lord. My lord, in para 6, the respondent authorities has admitted, my lord, I am entitled to get the,
Where is it?
my lord. Para 6, my lord, page 4, my lord.
Of the counter.
My lord, counter affidavit.
Para 6.
My lord. Page 3, my lord.
Was promoted as rank of Hildar with effect from 10/11 as per the judgment of the Guwahati High Court. Petitioner earned first organization and therefore petitioner is eligible to grant second and 12/8 on completion of 10 years. Following second granted the petitioner so and so, which is in terms of guideline. Yes.
Man, they have admitted, man.
Yes.
The only thing they are calculating that 10/10/97 implementation of that 10/10/97 notification as a promotion, my lord. If 10/10/97 has been implemented, my lord, my lord,
I think from your argument you want both. You want promotion as well as the upgradation. It appears like that.
my lord, it's if the promotion has been, my lord, what is that upgradation and
So
restructure?
you have to complete 10 years of service in a particular post to get the benefit.
My lord, if from 1994, my lord, if argument that it is a promotion, my lord, if from 94, if 10/10/97 has been implemented, it's 3 years, my lord.
What do you mean?
So how it can be promotion, my lord?
How can we do 3 years?
My lord, in 1994, I was enrolled, my lord,
You join the services.
joined the service,
Yes.
my lord. So, my lord can come to of the phase,
2004, you are entitled to from 2014. Then 2024 is another upgradation.
my lord, my
That's
lord,
all.
my lord.
Oh.
And my lord, in their affidavit, page 2, my lord, they have given me a chart. My lord can come to page.
Yes.
Page 2, my lord. The service particulars of the such and such petitioner, my lord. If my lord can come, serial number 3.
Sir, how many years of service you have rendered to get the promotion of Havildar?
Havaldar that was a re-designation of the post, my lord.
Of redesignation of
The post
which you joined.
which I joined, my lord.
What is the post you joined?
I joined as a rifleman, my lord.
Operator.
ORL, my lord. And it was re-designated
That
as
is operator radio line.
operator radio line.
So you joined. That was changed to the Havildar.
My lord. It was restructured as a Havaldar. So there,
According to you, from 1994, they have to take you into account 10 years of service to give you the first financial upgradation.
financial upgradation in the rank of the Havaldar, my lord.
Yes. And from that, after the first upgradation, another 10 years for the second upgradation.
Second upgradation.
So now in 24, you are eligible.
My lord.
That is your case. Wait. Yes, sir. What do you say, sir?
Lord, here, my lord. He joined in 94, my lord. Now, 1999, central government notified the ACP policy, my lord, assured career progression.
1995.
99, my lord.
99.
99, the policy came into, my lord, which provided for 2 financial upgradation in the lifetime, my lord, upon 12 years and 12 years, my lord.
12 years and 24 years.
12 and 24 years, my lord. In 2009, my lord, a modified policy came into picture. Instead of 12 plus 12, now it is 10 plus 10 plus 10. So 3,
Yes.
my lord. Now, my lord, pursuant to directions issued by this honorable court, my lord, in some other writ petition,
Guwahati High Court has passed.
Guwahati High Court, my lord, the rank of rifleman was upgraded to, my lord, to the rank of Havaldar. So all the riflemen, the rifleman is the lowest post in the Assam Rifles, my lord. The next
is Havildar.
Havaldar, my lord, and so on, there are some other posts, my lord. So there was a direction by this honorable court to redesignate all of them as Havaldar, my lord,
Yes.
with effect from 10/10/1997.
Upgrade them from 10/10/1997.
10/10/97. So since he joined in 1994, my lord, so he was upgraded with effect from 10/10/97 to the rank of Havaldar, my lord.
So according to you, he will be entitled to first upgradation after 10 years from
From
1997.
1997, my lord. And that is what we have granted them, my lord.
How do you say that he is entitled only from 1997?
Because the policy itself says, my lord, any upgradation will be set off against one of the career progression,
Where is it?
my lord.
See, when the scheme, what does the scheme say? Scheme says it retrospective effect.
My lord.
Does the scheme say it will have a retrospective effect? Let me see, the persons who are already there, who has completed 10 years of service, will be entitled to first upgradation, not a problem. It doesn't mean that from that date you have to complete 10 years. It is not so. But when you have gained the promotion to the post of Havildar, then from that date you will have to complete 10 years of service, is it not?
My lord, that's but the respondents are saying it's a promotion, my lord. Our case is that it's not a promotion. It's a
Upgradation. Redesignation.
redesignation, my lord.
Yes, sir. Yes.
It's
Where is the scheme?
Page 41 of the writ petition, my lord.
41 of the writ petition.
My lord, it starts from page 40, my lord.
I should carry progressive central government.
It pays 41 if Lordship kindly sees. My lord, pays 41. 41.
35.
41, my lord. Pays 45. 41.
Page 41, yes.
My lord, these are the clarification, my lord. Point number 35, my lord. So the question was whether placement appointment in higher scale of pay based on the recommendation of the pay commission or committee set up to rationalize the cadres is to be reckoned as promotion, financial upgradation and offset against the two financial upgradation applicable under the ACP scheme. Now the clarification given, my lord, in the third paragraph, my lord, it says where placement in a higher grade. On the right hand side, my lord, the third paragraph.
Placement in a higher grade involves assumption of higher responsibilities and
duties, then such upgradation will be viewed as
promotion or
upgradation.
How is this? When you redesignated the post, how do you say this will apply? You read the first one, where all posts placed in a higher pay scale, without change in designation, without requirement of any view qualification of holding a higher grade, not specific recruitment for existing post, without involving any change in responsibility duties, the placement of all incumbents against such upgraded posts is not to be treated as promotion or upgradation, where rationalization of restructuring involves creation of a number of hierarchical grades. Then this will be treated as promotion or upgradation. Sir, you have to give.
My lord.
You have to give in.
My lord, our case is, my lord, because here the facts, my lord, what happened, this order came 2 years back, my lord. He joined in 1994, my lord. In the usual course, he was granted promotion in the year 2012, my lord, to the rank of Havaldar.
Now,
in the usual course, through DPC, my lord, he was granted promotion to the rank of Havaldar. Then this honorable court issued a direction, so their promotion to Havaldar was taken with effect from 10/10/97, my lord, because of the.
sir, it is not a promotion, sir. You have redesignated the post,
My lord.
as Havildar.
My lord.
The lineman, ORL, is it not?
Yes, my lord.
Was redesignated as Havildar. And the initial date of entry will have to be taken into account for the purpose of upgradation. That's all, as simple as that.
No, that is the only issue involved, my lord.
That's all.
Whether one ACP or MACP can be set off against that upgradation, my lord. That is the only question, my lord.
You give him the benefit. You have to give them a benefit. Because it is very clear. 35, you read 3. 3 may not be applicable. Where placement in a higher grade involves assumption of higher responsibilities and duties, then such upgradation will be viewed as promotion. He has not given any higher responsibilities.
He has been given higher responsibilities, my lord.
What is the higher
Because
responsibility?
he was a rifleman earlier, my lord, which is at the bottom of the hierarchy, my lord.
Where is the promotion order given to him? Where is the promotion order? No promotion order.
He was granted promotion, my lord.
No? Show the order. Sir, please, when you come, please read and nail the point.
My lord,
Please, you can't expect me to read and assist you. I am not your junior now.
No.
After retirement, I'll come and instruct you.
it's not. My lord, the upgradation, my lord. The petitioner and other cadre, similarly situated cadres, my lord. There was a discrimination, my lord. I will show on by record.
Where is it? Sir, please, we are asking question. Answer that question. That is enough for me to write orders.
My lord, the promotion order is not on record, it appears, my lord. But your lordship kindly sees the sequence of events given by my friend, my lord. At serial number 3, lordship will see.
The list of dates.
My lord.
It's right. You will say promotion.
At serial number 2 and 3, my lord.
3 and 4 also promoted to the rank of so and so.
With effect from 1/3/2012. It is.
Where is the order, sir? Sir, you joined the service as a rifleman.
Yeah, brother.
Where is the order dated 13/3/2012?
My lord, that promotion order has not been served upon the petitioner, my lord.
What is the order served on you? Sir, when we wanted to help, when I wanted to help you and give you relief, you are not placing any materials. How can I pass orders?
When the matter comes tomorrow day after, I'll place the promotion order on it to indicate that this was a higher post, my lord, and that is why promotion was given, my lord. And the role,
That is why I asked you, if it is a promotion post and you will be treated as a promotee, then from that post you will have to render 10 years of service. If it is not a promotion post, if it is reclassification
My lord.
or designation has been changed, then from a date of entry, the period of 12 years, which have been now modified as 10 years, will be taken into account. You will be entitled to promotion in 2014, I'm sorry, not promotion. You will be entitled to upgradation, first upgradation in 2014, another one in 24.
My lord,
I have to write 2-page order. For that, you are not giving me any assistance.
my lord, as far as the upgradation and upgradation is concerned, my lord, we have filed an additional affidavit, my lord, wherein
That is not enough. We want the evidence to show, see, how can, my order will be tested in appeal. Then matter will be taken to the Supreme Court. I can't simply say that what you have stated is correct. In which case, I can also say his version is also correct.
my lord, just for page 26 of the additional affidavit, my lord, that will clarify it's a upgradation 10/10/96.
Page number 26 of?
26 of the additional affidavit, 23rd,
Dated 29th
29th
August 2018.
18 one.
Page number?
Page number 23 one.
So it starts at 50, sir, page number 50.
My lord. Page number 26, my lord.
Page number 26, sir.
My lord.
Twenty-six of? Your affidavit.
Yes, my lord.
Your affidavit.
My additional affidavit, my lord.
Your affidavit must be here. It's dated.
Dated
Additional affidavit has been filed on behalf of the petitioner to bring on record latest development and direction issued by the Ministry of Home Affairs.
no, my lord. That is an additional affidavit to bring on record the
Rejoinder affidavit. Which one here?
no, my lord. Additional affidavit, my lord.
Where is the additional affidavit? Dated
Dated 13 September 2018.
13 September. Yes. I think hereafter I have to put your case as the last one. I think I must take up your case as the last case, not the first case.
Page 26, my lord.
Page number 20.
6.
Yes, sir.
My lord. This is the later, it's clause D, my lord. Can see clause D.
Here.
Merger. This is concerning other clerks.
Merger of so-and-so on 10th October 27 in terms of letter dated so-and-so will not be counted as financial upgradation for award.
Not be counted, my lord. Promotion cannot be there. For the other clerk, they are not counting it as a promotion, my lord.
You're not counting it as a promotion, sir.
My lord.
but this is a merger, my lord. This is something totally different.
Merger and
Your
upgradation.
merger.
This is not, their case is not a merger, my lord. This talks about merger of Nayak clerk with Havaldar clerk on or after 10/10/97.
We'll call, get the document tomorrow.
10/97, my lord. In terms of the policy data.
I've understood your case. Give the document
No.
to show that we'll pass orders tomorrow. Orders tomorrow.
I pray for day after tomorrow, my lord. I have to get the documents.
Day after tomorrow.
My lord.
Post for orders day after tomorrow. See, if you're not going to do if you're going to argue like this, I'll post it after 6 months.
Sorry, madam.
And 20 minutes time, then by the time it gets to adjournments, then I'll forget.
Item number 2.
This matter pertains to Millard's.
This is 2, 3, and 4.
No, Millards. This is item number 2 of the main list, Millards.
Yes.
The list.
Yes, sir.
Well, it's the only issue to be decided over here was, well, as there was a selection process. As per the government of Meghalaya, Millards, the notification of 2017 says that there is 4% reservation for disability, people with disability, Millards. Now, when we had initially come before this honorable court, Millards, we had said that the respondent number 4 did not have any disability. We did not have the information. Subsequently, Millards, an affidavit has been filed bringing on record the disability of the respondent number 4 as well. In my humble submission, Millards, the only issue that would survive for consideration before your lordships would be that there are 54 posts, Millards, which were selected. The select list consists of 54 persons, Millards. 4%, Millards, would come to 2 point something. So, in my humble submission, Millards, there would have to be 2 posts that would have to be filled up by people with disability. The position here is, Millards, only one person has got the job. Both of us suffer from disability, Millards. Both of us suffer from locomotive disability. I suffer from 45% locomotive disability. Private respondent suffers from 50% locomotive disability. So, Millards, the issue, in my humble submission, would be, Millards.
Is it under 1995 Act?
Millards.
Person with Disability Act.
Disabilities Act.
Yes.
Because the government notification, which the government has taken a clear position, says, Millards, there is 4% available.
4%.
4% in the total cadre strength, Millards. So there were 54 people appointed.
Who is on the other side?
Exact figure of 4%. 4% comes to how much? Well, it's state is here.
I am appearing for private respondent, ma'am.
Who are you?
I am appearing for private respondent, my lord, who has been appointed. I have been appointed and I have joined.
But I think he is not disturbing you.
But
Only 2%
he had challenged my appointment initially.
No. Initially, now out of the 2 persons, 1 person has been appointed.
Lordship.
So you are not going to be disturbed now.
I'm not touching that, Millards.
You are not going to be disturbed. Yes, what do you say?
2.16.
My lord, would please come to page 18 of the writ petition, my lord.
18 of the writ petition.
Page 18, my lord.
Yes, sir.
Well, this is the reservation policy, my lord. We will come to 3% of the reservation, my lord.
3%?
But the state has clarified in its affidavit that this notification has been withdrawn. There's a subsequent notification of 2017. That's there in the state's affidavit. And I've got a copy of that notification.
I'm not aware of that, my lord.
But that's in the state's affidavit, Millards, which is 4%. Courtmaster, please. Because when we had initially come before the lordships, Millards, we were also under the impression it is 3%. State clarified, Millards, that it has been, the earlier notification of 2006 was repealed, and this notification came into effect on 7th August 2017. Millards, if your lordships kindly see, 4% of the total number of vacancies in the cadre strength.
Because there was an amendment.
Lordships.
Because previously it was only 3%. And there was an amendment.
2017 they amended it and made it 4%. Millards.
Yes. But when was the selection?
2017.
2017.
17 Millards.
And what is this, sir? 4% of total vacancies in the cadre strength.
Yes, my lord, I may be given a week time, my lord. I'll seek a clarification on this, my lord.
Oh, well. When the matter is taken up for hearing, the counsel and petitioner circulated office memorandum dated 7th August 2017 and contended that the reservation shall be made within the existing percentage of reservation of post in the category of Kasi, Jaintia and Ghara. That 4% of the total number of vacancies in the cadre strength would be filled with persons with the benchmark disabilities as specified thereunder. Full stop. The counsel appearing with the government would drew the attention of the court to the notification dated 30th October 2006 and submitted that the reservation fixed was 3% and not 4% as stated by the petitioner. However, you would submit that the notification dated 7th August 2017 has been furnished before this court now, and that he will get instruction and report the same the next date of hearing. The counsel appearing for the private party would submit that the writ petitioner is indirectly challenging the appointment order issued to the petitioner. They are appointed to the private respondent. Number 4. Full stop. At this stage, the counsel for the petitioner in response submitted that 2 vacancies will have to be filled up in the 54 vacancies identified, and that 1 vacancy alone has been filled up, and that 1 more vacancy is to be filled up, and that the petitioner is eligible based on the reservation of post mentioned in the notification dated 7th August 2017. At present, we are of the view that there is no threat to the private respondent, and depending upon the argument that is going to be addressed by the party, the private respondent will be heard if he is going to be dislodged from the post.
Well, it's just one small. I'm sorry, Melody. Just one small issue. The notification of 7th August 2017, Melody, categorically lays down that the earlier notification is cancelled.
That is right. It supersedes.
Lodge. It says, Melody, we cancelled it. This cancels the government office memorandum number so and so dated 30th 10 2006. Last line, Melody.
Yes, yes. See, that is why we asked whether it's a notification pursuant to the earlier one or now.
Melody.
2017.
They say it is under this, Melody. The state's affidavit says it is under.
I'll have to seek a clarification on that.
Sir?
I'll have to seek clarification on that point, madam.
If it's a 4%, then he has got to be accommodated.
If that be so, my lord, if that is the position.
Don't stand on technicalities. If you are otherwise eligible, give them, it will become infectious.
There were 2 persons, Melody, with disabilities. One has already got, Melody. I was out.
So that way, he's the person.
He's the person.
I got my for the reason, my lord, my name appeared much above him. My name in the select list appeared much above him.
That is different. If there are 2 vacancies,
Lost your hand.
he can be considered, that is all.
Obliged.
Fix a date, no? Schedule a date and give a date.
Item number 3.
May I please, Your Lordship?
Yes, madam.
In this matter, Your Lordship, in item number 3, the arguing counsel is indisposed for the day, Your Lordship. So I'm seeking adjournment. Let the matter be listed after 2 weeks.
Madam, after asking you only, the date has been fixed for argument.
My senior is indisposed for the
Don't
Lordship.
say senior's absence is good for juniors.
I have not been instructed, Your Lordship, to...
No, your senior need not instruct you. Take the bundle and read it. That's all. If you are present in the court, I would have given you the court paper to read. You must take the paper. See, Saturday, Sunday was a holiday. It's an opportunity for you to read.
No, actually, Lordship, he is not keeping well. He was supposed to go to Shillong.
No, see, I'm not saying that you are making incorrect statement. He may be unwell, but it's an opportunity for the juniors. See, first day, or after swearing in, I met the juniors. I said, you pray. If you believe in prayer, you pray. That senior doesn't come to the court. So you will get an opportunity to argue. Utilize the opportunities, madam.
Okay.
When do you want? Fix it, post the date. The request of the petitioner. What is the matter about? At least you know what is the matter about.
It's about non-consideration of the promotion of the petitioner to the post of rifleman GT.
Yes. Read. See, one senior is here to say, asking his junior to argue. I said, the senior be beside the junior. If I have any doubt, I'll ask the seniors.
But I have not been instructed.
See, you need not fear about the court. If you fear about the senior, ask him to go out to the court. Yes.
Much obliged.
Item number 4.
Yes.
My lord, this matter relates to termination of the writ petitioner from the post of assistant professor in Women College. Now the situation here, apart from government colleges, in the private and recognized colleges, there are 3 types of posts out there. Number 1, my lord.
This matter was already addressed before some other judge.
My lord, matter was taken up before the bench too.
No, I told them not to withdraw the parted matters, only fresh matters. The learned judge, I don't know who heard the matter earlier. Fear Providence Fund contribution between 2015, 16 or 18. Everything he has mentioned it. Yes.
Yeah. So
who is on the other side?
Lordship.
Ready. Lordship.
The government is you happy for the respondent state.
I am appearing for the university. University is also a party.
We are representing the college concerned.
College. Government.
Apologies. State is a formal party.
Formal party.
Yes.
Yes.
Well, there are 3 posts. Well, one is a government sanctioned post in the aided school.
One is the?
In the aided colleges or the recognized colleges, there are 3 posts are there. One is government sanctioned post, which they receive grant aid from the government. And number 2 post is college sanctioned post, but salary is borne by the management itself. And category number 3 is the ad hoc appointees, temporary appointees. This salary is also sponsored by the management itself. Here, case of the petitioner falls in the second category.
Secondary teachers.
Second category of a post.
Yes.
College sanctioned post. Now, in
only one teacher.
Only one teacher. One.
Yes.
One. No. In fact,
what is the reason for termination?
No reason was given, my lord. No notice was issued to him. No formal order was passed. Only email communication was given to him that the computer application department is not available in the women college from the beginning. Therefore, your engagement for nearly 9 years is no longer required. Therefore, he was. My contention is, my lord, the computer application is still there in the college.
Is there?
Is there. Now, under the university, my lord, 2 systems are there, my lord. Northeastern University, if they recognize the department, then the colleges can impart that education to the students. But there are another way, my lord, university may not recognize one particular department, but college can impart it. For example, the computer application. There are many colleges.
What is the proof to show that the college has that subject?
I'll show. But may just come to page number 27.
If there is a post and in which you are appointed,
yes,
and continues, then the termination may be illegal.
But
we'll see.
Only the problem, my lord, they did not issue me appointment letter. Lordship may come to page number 27 of the writ petition.
Of your?
Of my writ petition. Annex 2.
7.
I was appointed in 2013, but the appointment letter was not issued to him.
Department college also currently drawing so on.
Now, my lord, this is the letter issued by the college principal himself. Certified Mr. Ajit Paul is serving this college as a full-time lecturer in the Department of Computer Science since 2011. Currently drawing salary as such.
Where is the communication divesting of your duties? You have been divested of your duties, is it not?
Yes, yes.
You said you got the email communication.
Madam,
Where is that?
Madam, Thereafter, the next page 22 or 28, Lordship, can you see? Is GPF contribution also, page number 28. For temporary teachers, they are not allowed to participate in the GPF contribution. But for a college sanction post, they are allowed to contribute.
No, page number 28, annexure 3.
Annexure 3, my lord.
Consolidated statement of deposit of contributant provident fund.
Yes, he is allowed to participate because he's a regular appointee.
No. Even if you're a temporary employee, if you're going to work, you have to pay contribution.
My lord, I
That's what EPF Act says.
this was continued, and Lordship, kindly see, there was a request from him.
Previously, I don't know the subsequent amendment. Previously, if a person worked for 90 days, 30 days in a period of 90 days, the contribution will have to be paid. Yes. Now you have been working for 9 years. So they paid you, they deducted and paid you the contribution. Paid the contribution to the EPFO. Yes.
Lordship, kindly come to page number now.
Page number?
35.
35.
Madam, since appointment letter was never issued to him, he requested for issuance of the same. July 22nd. It was never issued to him. And later on, my lord, may come to page number 37 now. 37. In 2017, my lord, there was a redesignation of the post of lecturer into assistant professor. Madam, this is a notification issued.
Sir,
by the
right,
governing body.
Mr. Counsel, first I'll go through this. It's not a problem. Point out the communication given to you of divesting of your duties.
Madam,
That is required.
Madam, may I complete it? Stay with me. Page number 54.
54, yes.
54. Madam, on 14 December, he has written this letter. Now, with reference to be emailed to you dated 29 October and 10 December 2019 respectively, I would like to request you yet once again to clarify my current position in the college. Today being the last working day of the college for the current year, I would like you to kindly clarify the same so that it becomes easy for me to understand my future in this institution. Anticipation, so written by him. Now in the middle, 16 December, which we have challenged, I was of the opinion that you had been informed by the teachers representative of the governing body's decision.
1 minute. After 16 December 2019, is there any evidence or document to show that this department exists?
It is. Yes. Right. Lordship, kindly come back to page number 39. 39.
39.
39. 39.
The same book.
Madam, statement of fixation of salary, it is very clear. I'll show.
Yes.
Madam, name of the department, Women College, madam, name of the employee, Ajit Paul. Designation of the post held in which pay is to be fixed as such and such. Assistant professor in computer application.
Where is it?
Madam, serial number 3. Lordship, can you
page number 39, annexure 8.
Yes.
Yes.
Annexure 8.
Yes.
Point number 3, Lordship, can you see? Designation of post held in which pay is to be fixed as of.
This is the communication given to you.
But communication given to me.
That's a communication given to you.
Yes, yes.
On that date is it?
Yes.
See, please read the correspondence sent to you on 16th December.
Yes.
16th December. Where is
Page
the
number 54.
Huh?
Page number 54.
54.
Yes.
December.
Yes.
The governing body's decision
Yes.
to do away with the department in the college has never started as a separate department in the degree section.
Yes.
As of today, the department is not there in the college.
Yes, yes. But therefore now here they are referring, earlier they applied before the university to recognize this computer application in the department, in the college. University turned down, saying there is a lack of infrastructure. Subsequently, my lord, the college introduced this.
So till such time confirmation comes,
Yes.
they allow you to continue. When the confirmation is turned down, you are not entitled to the relief.
My lord. Here, therefore, in the beginning, I submitted, my lord, there are two types of imparting education. One department recognized by the university. Another one is department not recognized by university, yet college can impart the education to the student.
Because it doesn't have infrastructure. But how can you blame the university or the college?
Now, my lord, what the college sought for permission from university is a introduction of the PCA,
No question of?
Bachelor of Computer Application. Now that was turned down. Now, what the department was imparting computer education is short-term courses, skill-based courses in the college. I was engaged for that. And now I will show.
It is not in dispute. You have been engaged.
Yes.
You have been asked to teach computer application. Everything is correct. But ultimately, when the university has not given permission and the college did not have infrastructure, how do you say that you are entitled to continue in the post? That's all. As such as that.
My lordship is what follows from my lordship is regarding the department that required to be recognized by university and education imparted by the college. Here is the case, my lord. Department is not recognized by university, and yet there are many colleges in the state where they are imparting education even without that particular department is recognized by the university. And now this is one of the, for example, the computer application.
Even if the university doesn't recognize, illegally continue me.
But this is, and their certificate is recognized.
Yeah, wait. Yes, who are you?
Lordship, I'm the college concerned. This is a private college receiving grant in aid, Your Lordship. As your Lordship has
college.
Lordship, as your Lordship has held, Your Lordship, already, that there is no computer department in this college itself, Lordship.
Then why did you appoint him?
Lordship, he was appointed, he has never been appointed. His services has been taken from time to time for conducting some kind of short-term courses, Your Lordship, for which remuneration has been given to him there and then. I'll show that, Your Lordship. But before that, Lordship, there is no computer science department in this college. We are affiliated to the Northeastern Hill University, and this is the document placed by the university before this honorable court on earlier occasions also. So, Your Lordship, please kindly have a look at that. Lordship, the last paragraph is of consequence. The college currently does not have affiliation of this university to offer any program in computer science, Your Lordship. And what are the other departments which are available, Lordship, is in second para.
But you have appointed him the computer post.
We have never appointed him, Your Lordship.
What do you say about page number 39 or 36?
27, which he has referred to, Your Lordship, is answered by 35 itself. If Your Lordship is pleased to turn to page 35 of the writ petition. First of all, there is no department of computer science in this college, Your Lordship. So his claim of having been appointed to such a department does not arise. This is established by the document given by the Northeastern Hill University. Page 35, Your Lordship, will kindly see. Lordship, he claims that he has been appointed way back in 2011 and he's been serving. Lordship, page 35, which he has annexed. Lordship is dated 22nd July 2017. Lordship, here he writes to the principal, the undersigned takes this opportunity to communicate to the concerned authority to consider my tenure of service from 20th June to 2011 as a faculty in this institution in the Department of Computer Application and provide me an appointment letter. He's asking him to be considered for appointment, Your Lordship. So his claim of being appointed in 2011 and continuing does not arise because there is no such department. Now, why he was in the university, in the college, Your Lordship, Lordship may kindly turn to, and in what capacity?
Page number 39.
Lordship. Lordship, I'm coming to that. Why he was given this kind of pay scale, Your Lordship. I'm just coming to that in a minute. But in what capacity he was serving in the college, Your Lordship, that will be clear from the documents he has placed before this honorable court, Your Lordship. Lordship may kindly come to page 43, Your Lordship. These are the short-term courses and coaching classes, Lordship, who has been conducting in the college from time to time. There is no such post and of lecturer in a department. May I read, Your Lordship? Page 43. The undersigned would like to request you to kindly conduct coaching classes during the year 2014 for civil services banking staff selection examination and the integrated UGC sponsored service entry-level coaching classes to be held at Women's College, Shillong. The classes are scheduled to commence from so-and-so, 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 and the remuneration will be rupees 250 per class. Lordship, this is 2014. For every year such classes, page 45 is for 2015. Similar classes being conducted by him, for which remuneration is paid to him, Your Lordship. Lordship, kindly turn to page 47. This is with regard to 2017. Again, he is conducting such classes.
Yes. But is it possible for you to accommodate him to teach something, because computer applications are now very important?
Lordship, there is no such post, and also otherwise, because the higher secondary, because now as per the MBOS notification, Your Lordship, the higher secondary side has been bifurcated, Your Lordship. So otherwise also the college is not offering any class 11 and 12 any further, Your Lordship.
Only up to 10th standard.
Lordship, degree classes are being offered by the college. So, and the management of the higher secondary section is totally different, Your Lordship. All that is on record and is fully aware of, because this is as per the MBOS notification. It is not on our own doing, which has come into effect from 2019, Your Lordship. And that is why, in response to his query that what is my status in the college now, we have informed that this is the email which he was referring to, Your Lordship. That no such department exists. More so, Your Lordship, because of the bifurcation of the higher secondary section from the degree. So my humble submission, Your Lordship, there is no case made out for interference of this honorable court, and one judgment Lordship is fully aware of. That Lordship, because, may I refer to it, or if after
yes.
my...
Refer.
Lordship. St. Mary's. List of books.
So contention is that when the post ceases to exist, or when there is no post exists, there is no right to demand.
Lordship.
That's your
Lordship. And Lordship, because this is a private college, Your Lordship. So this is, there is a...
it's not a private college. It's an aid.
Lordship. Private college receiving aid, Your Lordship, but for not all the posts, Your Lordship. That he himself claims, Your Lordship. Only certain posts are receiving grant and aid for the... So the rest is by the college, Your Lordship.
Yes.
Lordship, 2023 for SCC, page 498. Judgment. Lordship, I am referring to para 75.2 at page 537.
537,
Lordship. The second part of this para, Your Lordship, whenever courts have interfered in their exercise of jurisdiction under Article 226, either the service conditions were regulated by statutory provisions, or the employer had the status of state within the expansive definition under Article 12, or it was found that the action complained of has public law element. Lordship, but in this instant case, Your Lordship,
yes.
Lordship, may I read further? Lordship, para 75.5. Because our case is also similar, Your Lordship. From the pleadings in the original writ petition, it is apparent that no element of any public law is agitated or otherwise made out. In other words, the action challenged has no public element, and writ of mandamus cannot be issued as the action was essentially of a private character, Your Lordship. So my humble submission, Your Lordship, If at all it is some kind of a contractual arrangement which the petitioner has with the college concerned, Your Lordship. And as such, Lordship,
See, in this judgment also, they have considered about the maintainability of the writ petition.
Lordship,
If there is a public law duty or when there is a statutory violation,
Lordship,
writ petition is maintainable.
Lordship.
Writ petition is maintainable.
But in this, my humble submission, Lordship, there is no statutory violation in this instant case, Your Lordship. And the college does not come under the definition of state under Article 12, Lordship, of the Constitution.
Yes. Yes. Ultimately, I think the answer lies in para 66.
Lordship. Deeply obliged, Lordship.
That's your point.
Lordship.
Yes, sir.
No, I am appealing for the university, only for the limited purpose to make an inquiry on whether this department, computer science, has been affiliated to the university. We have verified from the records, it has not been. So, and I think my learned senior friend will please that communication before the launch.
No case.
Well, I'll show on a few documents with Lordship permission the existence of the computer department. Lordship, can you see my rejoinder affidavit dated 24 August 2022?
Page number?
My Lord. Rejoinder affidavit dated 24 August 2022. My rejoinder affidavit.
Rejoinder.
Rejoinder.
24th August
My Lord.
17. Yes, sir. Which page?
Now, may I come to Lordship permission? Page number 24. Lordship, may I come to page number 24 onwards? Now, here the college is saying that computer application is not there in the college. One admitted fact, my Lord, keep in mind, computer application in the women college is not affiliated to university. That I'm not disputing. So they did not grant. But for short-term courses,
No grant.
no grant, no affiliations. But for imparting short-term courses, department is still there. I was engaged for that. And now this is the...
You have been engaged as of course, terminal benefits and other things have been given.
Yes.
As if you are a professor or lecturer in computer applications.
Yes. As a lecturer in the first occasion, subsequently assistant professor.
But some of the communication says that you have been appointed as a resource person.
But that is against the
That's
report.
right. It's a nomenclature, different terminology is in use.
Right.
But ultimately, you must understand one thing. Whether there is a public duty, element of public law is there, number one. Number two, this subject doesn't get grant in aid. Number three, the post doesn't exist. Even assuming it exists,
Yes,
the university has not recognized it.
that is.
On these grounds, you are not entitled to.
But I'll just, with short time, within a short time.
You are a senior man, you need not waste the time of the court.
My Lord, page number 24, Lord, with Lordship permission.
Yes.
My Lord, this is the all India survey of higher education. These are the feedbacks given by the college to college itself. Now, Lordship, page 25. basic information college name is there. Now, may I come to page number 27. This is the data submitted to the Ministry of Human Resources by the college. Page number 27. Faculty name.
Page 27.
27. Faculty name.
One minute. 20. Two different type numbers are there.
Page 27.
Registry will give one number, they will give one number. Yes, yes, sir. Computer application.
Faculty name, computer application. Now, my lord, serial number 1, 2, 3, 5, 6 onwards are the recognized affiliated departments in the university.
Computer application is there.
Yes, it is there. It is there. So this is the feedback given to the government of India by the college. And this was continued. Page number, my lord.
Sir, this is an application submitted by them.
Yes.
Prosecuted. After that, they will come and verify, inspect. If that is not granted, that's the end of it.
No, this feedback is given to the Union of India, not for recognition, but to upgrade the status of the college. And Lordship, kindly come to the faculty, the teaching posts. Lordship, kindly come to page number 30. 30 of the same rejoined evidence. My lord, in the middle department computer application, my lord, the number of teachers in position for computer application, number 1.
Yes.
1 post is there. This is referring to me. And now, Roshan, can kindly come to page number 43. Now, this is 2015 data. Same thing, I'll come to page number 46.
46.
46. And my lord, we come to 47, serial number 11, computer application. The department is still in existence, 2014. And the sanction post, my lord, we come to 53, page number 53. One sanction post is there. Page number
So
5.
according to you, they've been recognized by the university and affiliated.
But though it is not recognized by the university, not his university, but this computer application is existing in the college, and they furnish these particulars to the Human Resource Ministry for upgradation of the college performances. Page number 53.
60?
53, 53.
50.
53, 53.
53.
53. Faculty position, my lord.
Yes.
One position is still there. 2015. And I'll show 2016 also, page number 62A. Given to the government of India, man. I'll come to, with lordship permission, page number 62E, man. Page
62?
62E, man.
E,
man.
computer.
Serial number 10, computer application. And the staff strength is reflected at page number 52J, 62K.
62A.
62K.
K.
Man.
Yes.
Well, position number 1. And now, my lord, come to page number 60. It is interesting. Now, one senior friend argued that for class 12, computer education is not imparted there. Russian kindly see this syllabus of 2019-20, page number 63. Is it 63?
63.
My lord. Department of Computer Science and Application, Women's College, Baitumgra, Shillong. Course certificate in office automation, class 10 plus 2. These are the syllabus are there. They are still imparting. I will not take the other pages. These are the syllabus. And
they are not saying that they have imported, they are not imparting computer science to the students. But As a resource person, you are coming, for which you are paid remuneration,
Right.
and PF has been deducted and remitted, but you are not a regular employee. More so, when they say the post has been abolished, how can you demand now?
My lord, it is not a, my lord, my appointment is not temporary. It is not a resource person. But the appointment letter itself is page 39, Lordship has seen. Lordship, kindly come to the last annexure I will refer to, page number, my lord, 82. The syllabus of prospectus of 2022.
See, don't you have an education code? Don't you have authorities? You have to go and approach the authority concerned. How is the writ petition maintainable?
I'll just cite one judgment with Lordship permission. I'll just cite one judgment regarding that maintainability, since they have raised it.
Yes.
Page number, my lord, 83.
80?
83.
Yes, sir. Women's College.
Is the prospectus of 2022. This point, my lord, I'll come to how they do with this is instead of, my lord, retaining the designation of, my lord, department designation of computer application, they have designated into web code. Go to your website. Lordship, kindly come to page number 94.
94.
94.
Yes.
94. Now, madam, may I just read, madam? NEP 2022 focuses on skill development program wherein it supports beginner by bringing innovative skills and technologies to the community for better quality of lifestyle and livelihood, and which in the long run would create a sustainable and visible social impact. These programs emphasize on stimulating a scientific outlook among members of the community and develop scientific attitude, curiosity, and capability to experiment and adopt new skills and innovation to improve their lifestyle and livelihood. This would, in the passage of time, contribute towards the upliftment of society as a whole. Abiding by the objective of NEP 2020, Women's College Shillong also introduced a wide array of certificate courses besides the standard academic program prescribed by the university. Students of the institutions are expected to make choices of at least one of such courses in a year based on their choice of interest, which would help in boosting their knowledge in specialized areas as well as strengthen their core skills to create opportunities for them in the future. These courses are open to anyone in addition to the students of college. The courses are, my lord. Now, number 2, go to your website. But the same, it is the designation is changed, but the syllabus are same. Short-term courses, my lord, 6 months courses are still continued both for class 11 and 12, and even graduation till today. And the last page, the last paper I'll show, my lord. Lordship, can you see? Page number, my lord. I'll come to page number 76.
76.
76. But it is the faculty in the university, in the college. But at the bottom, my lord, computer application, Mr. Ajit Paul, cloud and computing introduction. But here's a charter of duties.
Yes, 2014.
14. This will continue 2016 also, page number 79. 2017 also, page number 80. Therefore, the submission of the learned at the college, that department is not in existence. Affiliation is not there, I admit. But the computer department is still there, imparting 6 months courses, for which I was appointed, for which I was regularized. But,
Madam, are you teaching computer applications even now?
No, Your Lordship. First of all, Your Lordship, because the higher secondary section, Your Lordship, in which he claims he was teaching these courses, this has been bifurcated, Your Lordship, by an embossed notification.
Bifurcated.
Lordship. Higher secondary section is bifurcated. Lordship, it is not there.
So up to 10th standard, up to class of 10 available.
No, Lordship, we are teaching only degree courses, Lordship, in the
Teaching
college.
only degree.
We are teaching degree courses.
Both the curriculum was there.
Lordship, earlier the higher secondary and the degree was there.
Higher secondary and degree was there. What he claims to be teaching, Lordship, those were in 11 and 12, which was part of the higher secondary sections. Due to the embossed notification in 2019, Your Lordship, the higher secondary section has been bifurcated, Your Lordship.
Lordship, now this 11-12 is part of the schools, Your Lordship. It is not part of the colleges. So now there is a totally different management for the higher secondary section, Your Lordship. What he is claiming, Your Lordship, admittedly on his own showing, are skill development.
Is what you are indirectly asking them, ask them to have 10 plus 2, I mean plus 2 again, schooling again in the college.
Which
is not permissible.
It is not in our hands otherwise also, Your Lordship, because it has been bifurcated already.
It is the same college, the imparting class 11 and 12 plus university, the degree level.
Lordship, this is on our
In 2019 it has been stopped.
But it is still continuing.
Where is the proof, madam?
Lordship, it is bifurcated. The notification is there, Your Lordship.
All the colleges lecturers are still teaching in the class 11 and 12 till today.
We have not brought that on record, Your Lordship, but if Your Lordship permits us, I can bring it tomorrow. I can bring it tomorrow, Your Lordship.
Yes. That's all. Yes. Pass orders.
Obliged, Lordship.
Other cases are tomorrow or some other day. I'll dictate immediately.
Madam, may I just cite one judgment, Lordship, regarding the...
Give the judgment.
I'll
What
just
is
raise
the
a judgment.
name of the case?
The name of the case, my lord, the 2012 SSC, page 331, Ramesh Ahula versus State of Punjab in others. I've given the citation in the morning also.
Probably they would have referred to Anadi Mukta case, 1989. Has they referred it?
Lordship, we have given some other judgments also, but Anitha Mukta is, we have got it now.
1989. Yes, here that also refer, madam. 1989 judgment also refer.
It has been referred to here.
It is also refer.
Anadi Mukta. 1989 to SEC, they mentioned it.
Yes.
My lord, as I've stated earlier, my lord, state is a common party.
That's right.
No relief is sought against the state.
See, now the issue is they had a comparative applications till 2019 and he was employed and he was given a job, provident fund, everything has been deducted. In 2019, there is a bifurcation. College has come, school has gone. Now, when there is no place for school in the college, namely the +1 and +2, he cannot demand that I should be entitled to teach. That is all. That's a sum substance. Take the order. Other cases, you give the date, the convenience. Yes. And finish this matter. Other cases, you take the date. Now itself you come. Send the papers.